Hey everyone, this is Layla Shaver with My RA Lawyer coming to you with another episode of the 10 stupid things your CCO is doing. So today we're going to talk about overcharging clients. That's right. So if your investment management agreement or investment advisory agreement has one agreed upon fee stated, and ultimately, when you go back into your quarterly billing and look back, that same client is being charged a different amount. Now, this can be an issue, whether it's under or over the stated amount in the agreement, but it's much bigger of an issue if it's over the amount. So today I'm going to talk to you about the matter of Barclays Capital Inc. Administrative Proceeding number 3-17978. So Barclays Capital is duly registered as a BD and an investment advisory firm, and they were improperly charging certain advisory clients, overcharging them by almost $50 million. So $48 million of it was accounted for, and those clients were people who they falsely represented to them that they were being provided certain due diligence services and that certain third-party money managers were being monitored by Barclays when they actually weren't. And that group constituted $48 million of that overcharge. The $2 million were clients who just were charged excess fees. So the first group were charged excess fees for services they actually weren't in fact receiving. The second group just excess, so a percentage different from what was stated on their agreement. Also, Barclays Capital, for a period of about 5 years between 2010 and 2015, had been selling mutual fund shares that were more expensive than other shares that were available at a lower cost. So because they were telling clients they were providing certain services they actually weren't, this was considered material misstatements in Form ADV. They were also found to fail to have disclosed material facts in relation to the mutual fund share types, and also failure to have proper policies and procedures to address all these issues. Ultimately, Barclays was forced to pay $3,504,285 for underperformance for advisory strategies, a penalty of $30 million for falsely representing the services they were providing clients, and then $63.5 million in disgorgement and interest, and those were for the mutual fund shares, as well as for the access fees paid. So huge penalties arising out of the fact that excess fees were charged to these clients. Now, granted, most of them were excess fees charged for services they weren't being provided, but it happens in every firm inevitably where a client or clients are being charged more than what was agreed upon. So this is a big issue at the SEC, especially where the actual fee being charged is more than what's been agreed upon, but they'll still bring it up as an issue even if the fee charge is less than what's in the investment advisory agreement, because their concern is that you start off with one fee and then there's no documentation or written acknowledgement of any sort as to why that fee has changed, whether it's less than or more than what is stated in the investment advisory agreement. So it's very important to document. Even if you're just providing clients a discount just because you want to be a great advisor, or maybe the performance wasn't as great as you thought it was and it was something you thought would make your clients happy, you still want to document it. And it's frankly great marketing if you do something like that. You send out a letter to your clients saying, hey, performance of our model portfolio, for example, wasn't as great. We're giving you guys a, 0.5% reduction in our fees. It's documented, all your clients receive it, they can acknowledge that that's what happened. You make them happy. I mean, I'm not saying you have to do that, but it is a strategy. Either way, you want to make sure you're documenting it, and you want to make sure it's in each of your clients' files. If you find out you've made a mistake, go ahead, call the custodian, see what the process is in reimbursing that client's account and making them whole again. And then make sure you immediately notify the client as soon as you realize that a error has been made. This is why it's really important after you've done your billing, whether it's on a monthly, quarterly, semi-annual, or annual basis, that after it's happened, that you've double checked it. I mean, you should double check it anyway before the fees are taken out. But after they've been taken, go back and review them again. Make sure they're accurate. That way there's not a whole lot of time that's elapsed between the time the fee was paid and when you've caught the mistake. So this is a more recent case, and if anything, it shows a current trend with the SEC. They're really pushing these fines. You know, something like this, Barclays had about $12.8 billion in AUM as of 2015, and they were facing a $30 million penalty. That's super significant. Not only that, but this is something they now have to disclose on Form ADV going forward. So you really want to be careful. This is an easy mistake to catch in terms of charging excess fees. And you also want to be careful about services you're providing, and that if you're marketing them, that you are in fact providing those services to your clients. Anyway, if this is something that you're facing in your firm, or perhaps you're just concerned about what's happening that you don't know about, give us a call today, 770-462-2118. You can email me directly, Layla at myralawyer.com. That's Leila at myralawyer.com, and schedule a consultation. Don't wait another minute. The SEC is making bank off of you, and they're not going to stop doing it. They're going to come after you, and they're going to make sure you're paying fines for your mistakes. So find out what you're doing before they do. Have a great day.